noise from the campground, light pollution, possible damage to ball capacity, safety of the campground customers in regards to hunting and target shooting, trespassing issues, increased traffic and negative impact on town roads. No 24-hour on-site campground manager is proposed. Nothing is in place to prohibit the expansion. I would like to see this application tabled until the county and town have measures in place to regulate this type of commercial property, but this horse may already be out of the barn. If the conditional use permit is approved, I'd like to see the following: a fence and private property signs along all of the property lines of neighboring properties. Quiet time from customers from 10 p.m. to 8 a.m. Upper zones of 200 feet established along property lines. 24-hour manager on site. No further expansion. No street lights, barn lights, mercury lights, or similar lights within 300 feet of adjacent dwellings. There are now two ways about it. This campground will negative effect, or I should say there are no two ways about it. This campground will negatively affect our and our neighbors' recreation quality of life. We also received a letter July 24, 2023 from signed Andrew Stephenson, owner of LR 378, Todd Stephenson, co-owner of LR 381, Jimmy Stephenson, co-owner of LR 381. And are they here? So they provided a letter showing at least their location. They provided a map that showed their location in relationship to where the campground is going to go. And it appears these are parcels to the west, on the other side of Highway Y to the north. And they would like to express their concerns in reference to the permit application cited above. These concerns are not presented in any order. Again, and there's paragraphs that go behind these. Decline in wildlife habitat, fire danger, noise level, hunting, traffic, air quality, and again, final thoughts. We purchased our small piece of Northwoods to relax, escape the hustle of southern Wisconsin. More important now than in previous decades, as with so many others who love the Northwoods. You personally, as residents and committee members of Oneida County, will give serious thought to our concerns. And they also talk about property value that would decrease. I already think I gave you this one. Oh no, Randy Orwaska is here. And I'm ready to express my opposition to the conditional use permit application proposed by Gabriel and Denise. I talked to a few people who live nearby. Their concerns that parallel line. I'm one of four owners of the property located at 2598 County Highway Y. They give a parcel number. And again, they go through loss of property values, noise, light pollution, possible diminished bulk capacity, campground, trespassing, increased traffic, 24-hour on-site. Then we've read that. Merrill Kelch is here. And then I state I tire of people taking advantage of town and almost loose and non-existent zoning rules. Here's the zoning use and consistently allows for the belief that it's okay to take advantage of neighboring landowners. The Combs leadership has left the general use zoning carried on way too long at the expense of said neighboring landowners. Simply, it's not okay or right. And my family and I own land that borders the entire north border and touches the southeast corner of the Los campground. We bought the land for recreational purposes. Say yes to this proposed campground puts 150 to 200 year-long campers right on our property lines. I am under the understanding that Oneida County doesn't have statutes rules regarding campgrounds. Neither is town of Tacoma. This only leaves us with common sense. Common sense tells us avoid safety issues. My preference is to vote no. Email from Dan Condon. Dear committee members, I'm one of my cabin owners, Bradley Johnson, pretty much summed up all my concerns with the proposed campground. I am 29 years old, newly married, starting a family. We have grown into a small piece of property. They have made friends with many landowners. My kids learned to fish on nearby lakes. My investment in 1997 was with the intention of never selling, but turning my share over to my son. Now I sit here thinking about the proposed campground. I wonder what our property would be thought of if we could get a fair market price for our shack. I might consider selling, but we in the right mind want to buy our place with a campground surrounding the property. And then here's the letter I've attached. This is from K. Kladowski. I've attached a personal letter of support. And it is from Kate. I'm writing this on behalf of Gabriel and Denise. I have been an observer at both of the Columbus Town Board meetings where this issue was presented, their original and modified plans. They were prepared and professional. They had obviously given a lot of time to the plans. I think they should be allowed to move forward with the development of the campground. I would also like to address two of the conditions in Columbus Town Board attached. The 8-foot fence that would surround the property, intended to serve as a sound barrier and physical barrier, and the campground quiet hours. The 8-foot fence was recommended as a safety barrier between campers and live gun ranges adjacent to the campground. It's my belief that safety is responsibility of the gun range owners. Safety barriers should be in place around any active shooting range. I believe a visible barrier such as cedar pole fence, chain link fence would suffice. I would also like to request that quiet hours be set and adhered to as long as the adjacent property owners are adhering to the same quiet time. If the adjacent gun ranges are being utilized at 7 a.m., it's unfair to require the residents of the campground to adhere to that rule. On a personal level, I would like to extend an apology. They have been unfairly treated with rudeness and disrespect by some of the residents and attendants of the town board meetings. No one deserves to be treated that way. Please allow them to move forward. And that is the public comment.
Thank you, Carol. Any questions from the committee before we open it up to the public? Okay.
I just want to hear Mr. Devlin speak.
Well, that's what I was going to say. We'll open up for a public comment. Anybody now want to come up on this campground issue?
So I'm Derek Mean. I own the property, the shooting range that they're referencing. I own that, and I own 360 acres that borders the proposed campground. My biggest concerns are the trespassing piece, and that people are aware that there's a shooting range there, so that I'm not wasting county resources and people come over or come onto my property to talk about me not shooting or the noise and all that kind of stuff. Along with that, I'm also concerned about fire because we own, like I said, I own a lot that's a tree farm, so I own quite a bit of timber there as well. So those were my major concerns, was that there's a fence provided. I don't think it would be sufficient just to go on the east side, because you just walk around it. I'm concerned, my biggest concern is the computation piece. When I shoot back there, I have berms. It was made as a shooting range, so that part is all safe. I'm not worried about shooting towards that or anything like that. I'm mostly concerned about the noise level, and that people are aware when they come to camp there that there's a shooting range. Most of the campsites, I shouldn't say most, but a lot of them are located along that east property line, which, as I said, butts all the way up this line. So the fire piece and that piece is my two biggest concerns. That's not
Public comment.
Yeah, okay, sorry. Thank you.
Anybody else? Okay.
So my name is Edith Shane. I'm a disabled Army veteran. And a year and a half ago, I purchased 5 acres on 2626 County line in the town of Nokomis. It adjoins to my sister and brother-in-law's land, and also his brother who owns 5 acres. My main purpose of this purchase was to place a cabin for myself to get away from serenity, hunting, fishing, snowmobiling, and ATVing. We are avid gun owners, and we target and trap really frequently. I deer hunt, and I have permission to hunt the acres owned by my brother-in-law, including my own. And in the future, our plans were to build a house and retire in this area. I have local ties to quite a few people in the area, and I ultimately enjoy it up there. I received the notice 2 weeks ago for this board meeting, a 60-site campground with a few cabins directly next to me. My heart sank. My quiet little cabin was now going to be overrun with people, noise, fires, pets, and traffic. Quiet mornings sitting in my pine tree lined lot will now be overrun. Normally quiet weekends will now be overpopulated by well over 100 to 200 people. The first 3 criteria for approving or denying a cup are as follows. The establishment, maintenance, and operation of the conditional use will not be detrimental or endanger the public health, safety, morals, comfort, or general welfare. The second one is the uses, values, and enjoyment of neighboring property shall not be substantially impaired or diminished by the establishment, maintenance, or operation of the conditional use. And number 3 is the proposed conditional use is compatible with the use of adjacent land and any adopted local plans for the area. Having a campground directly next to my property will negatively affect me in the following ways. It negatively affects my comfort, morals, safety, and general welfare. As I stated when I introduced myself, I'm a disabled Army veteran. It's very therapeutic for me to get away and escape to the North Woods. Now I'm going to be met with congestion and stress. Safety is a huge concern for me also, with the amount of people being within walking distance to my place, and I'm concerned with trespassers, theft, accidents. I greatly enjoy being able to have a window open in the evening for the fresh air or just sitting on my deck, listening to wildlife, and now all that's going to be stripped for me. Noise and light pollution are also a very large concern for me. The use, value, and enjoyment of my property will be substantially impaired. With having the campground next to my property, the main use of hunting, target shooting will be diminished. This will impact my enjoyment and in turn, my property value. The sale of my property is going to be imminent if this is approved, and my value will plummet. Selling a property next to a busy, high populated establishment is not a selling point. All of my time, money, and heart that I put into this property is going to be for nothing. The proposed conditional use is not compatible with the use of adjacent land. The entire land in that area is mostly used for hunting. Placing a busy campground will impede on the wildlife and directly impact my hunting and enjoyment of firearms. In addition, it's going to increase nuisance animals, skunks, raccoons, bears, which the current landowners and I are very careful trying to keep under control. I would like to note that I served on the town board of the village of Crivets, which is also a very small town. And my job as the town chairman was to speak for the town citizens. The town of Nokomis is in the process of rezoning, which is grossly overdue. Growth in this area has been great and the zoning has stayed the same, which is minimal at best. I do understand that a town board meeting only has to be posted in the village hall and 2 other public places. But for something this significant, there really should be a more modern way of notifying property owners of such a change. Almost everyone has an email nowadays, and I would like to publicly state that I would like to see an email or letter sent for significant changes at meetings. If I had been notified of the meeting for the town, I would have been there to voice my concerns as I am here today. In addition, Oneida County is also looking at creating a moratorium for campgrounds in the entire county, but it has not been pushed through. Clearly, this campground is trying to get passed quickly in order to beat out the rezoning and the moratorium. I feel that the campground should at least be tabled as the town has completed the rezoning and or Oneida County has passed their moratorium. The campground is a terrible idea and affects all the land bearers in the direct area. This was brought up in a few months, and in a few months it would have never even made it to start. So why are we considering it today when it clearly should have never been? And why are the rights of this landowner more powerful than the rights of my own? Lastly, I would like to directly note to the Pascales, when purchasing my land on 2626 Countywide, the first thing I did was go meet my neighbors that I did not know. I spoke to Brad and Dan, I introduced myself, I asked questions, I asked permission to do things like target shooting.
Okay, we got it.
Okay. I also introduced them to my 100-pound German Shepherd and let them know since we are due, if he wanders, please let me know. Good neighbors are courteous and try to keep a healthy and friendly relationship.
Maybe my better half of the property, but if the county is considering a moratorium on campgrounds, in the future to allow one now, the optics don't look good. You either open the floodgates for more campgrounds, or you're showing preference to someone, you know, who's, again, just sneaking under the wire before you have an ordinance in place. I do think there are also optics associated with putting a campground next to hunting areas. And their bullets don't stop because of property line. The gun range is another concern. And the property that we own and other properties the Kelches own are, you know, red pine plantations, and there's, you know, a blanket of pine needles there. And, you know, 60 campfires on a windy day or fireworks, you know, could have a wildfire. So I think, you know, what I'm asking is that you table this vote until you guys make a final decision on moratorium and make a decision after that. But to show preference to one landowner or to one, you know, group who wants to have a campground and then shut off that option to everybody else, the optics just aren't good.
Thank you. Anybody else? Anybody else want to speak on the campground? Not oppose the portion of the public hearing to the campgrounds? Then back to committee questions from the committee to the, either to Carl or
The 8-foot high fence, that's on the north, east, and south side, correct? Of the property?
There's a new kind of fence, so we had an open fence plan around the whole property.
I mean, okay. So there's not gonna be a barrier?
There, we still may do the wood fence on that property that butts in ours,
Okay.
just to protect our office area from his property.
So you're talking about the property owner,
Yeah, it's really small.
yeah, that one has, where, I just saw the conditional use permit said that there'd be an 8-foot high fence.
Yeah, it looks like it's to the north, to the west, east, to the south, not along Highway Y, but then also around that property.
Yeah, so then we redid the plan, site plans through our engineering, about 2 weeks ago, so. Originally we had the fence on that east side and south, but the new plan showed an open fence around the entire property. And just to show that we had open to it, but we didn't see it necessary to do a wood fence around the entire property.
Gotcha.
So there is a fence on the north, east, and south side.
Yeah, there'll be a fence around the entire property here.
When does the camp close? No, they talk about hunting and bullets. Hunting season is in the end of, bullets is in the end of November. Are you guys got campers in the end of November?
The end of October, but the cabins will be available year round.
any other questions? Not? Anybody want to entertain a motion to approve, deny, accept, move forward?
The moratorium wouldn't count, wouldn't take in, it's too late already.
It's too late.
Anybody that's applied for the campground moratorium is already too late.
Right, and same thing with any zoning change, it's too late. It is the day that the paperwork was made or the suggestion was made. Am I correct with that? Also?
Yes.
Yes, the rule found they applied for the permit, they paid for the permit. At the time of property zone to September 10, general use, campgrounds is allowed use, conditions of conditional use permit, so you can't retroactively build the property, and you can't retroactively do a moratorium. The moratorium language is on this. Further down.
Ready? What do we want to do?
Possible moratorium was going to be for large campgrounds, 400 sites, 300 sites, or what was that?
The last meeting, the committee voted to have a county-wide moratorium on campgrounds. So the language you'll be reviewing is a moratorium that prohibits the issuance of conditional use permits for campgrounds. Period.
Till we can,
That's,
Yeah.
not
You're
sure.
looking at false language today.
Yeah.
And whatever that amendment or the ordinance changes would be, this comes in free. That comes into today's standard.
Basically, we don't have anything around for tonight. I will make the motion to approve number 6 on the agenda for the conditional use permit.
What, all, is there a second to that motion?
No second.
And a second. Further discussion?
I guess the only thing I would say is just on the 8-foot fence.
Can't
that-
hear you back here.
Oh, I guess on the, my only thing would be on the 8-foot fence that, kids that are wandering and playing can't go through the fence. It's an 8-foot fence that's hard to get over and, hard for kids to get through. So,
We have kids of our own, so we understand that.
With that, all in favor, signify by aye. Aye. Opposed? Motion carried. Excuse me. Item number 7 is administrative review permit 220012, authored by the Planning and Zoning Committee to consider amending, suspending, or revoking administrative review permit 220012 for property described as the Village of Minocqua, Lot 2, Block 3, Section 14, Town 39 North, Range 6 East, PIN numbers W3239 and MI 3240, 329 East Front Street, the Town of Minocqua.
Mr. Kittens, if I may, this is being transcribed by a court reporter, so if we could make sure that people, speak one at a time, the first time you speak, if you can say and spell your name, and spell your last name, just so that we can have an orderly record moving forward. Thank you.
Okay, Mike Timmons, acting chair for today's Planning Development Committee, TIMMONS. And I'll continue reading our agenda. Pursuant to section 9.82, Rent D of the Oneida County Zoning and Shoreline Protection Ordinance, the committee shall retain continuing jurisdiction over all activities authorized by permits for the purpose of ensuring compliance with this ordinance and other ordinance in terms of this permit. Such authority shall be in addition to the enforcement authority of the zoning administrator. Upon notice to the committee or an alleged violation of any permit in its sole discretion, the committee may hold a public hearing to consider amending, suspending, or revoking this permit. Notice a hearing that's the alleged violation shall be served upon the property owner and permit holder either in person or via certified email to the address provided on the permit application or otherwise provided the department a minimum of 72 hours prior to conducting a public hearing. The notice shall contain the date, the time, and the place of the hearing, the description of the property, the description of the activity authorized in the permit, and the statement of the alleged violations. Notice shall also be published as a Class 2 notice. Any person may appear at such public hearing and testify in person or be represented by an agent or an attorney. The committee at its sole discretion may hold additional public hearings if the committee finds after the hearing that the permit holder is not in compliance with the terms of the permit. It may amend or suspend or revoke the permit. The decision of this committee shall be furnished to the permit holder in writing, stating the reasons therefore. Excuse me. A, staff will be giving a presentation that will include describing the administrative review permit. I've said numerous times already, and the conditions attached to that permit, correspondences between the applicant and the Oneida County staff and representatives, and a timeline of staff observed violations of the ARP of 2200-112. Then the applicant will have his opportunity to provide his comments and testimony. And then after that, C will be public comment. There will be 3-minute comment taken. And remember, this is on the strictly on the administrative review permit. This is not on any other things but that. With that, Mr. Jendrich.
Thank you. And I gotta get some legals out of the way. This was published in Northwoods River News, July 11th and 18th, 2023. I do have a proof, or actually the original proof of publication in the file. It was sent certified mail to the owner, Kirk Bangstad, at 2 different addresses. First class mail to the town clerk and to the town chair. First class mail to property owners within 300 feet of the property. Sent interdepartment mail to Mike Fugel, Corporation Counsel, Tom Ryden, District 18 Supervisor, and email to the county clerk, DNR, DOT, and to individuals who all wanted to be notified. I was going to say, Mr. Banks should sit up there.
Thank you, sir.
As far as the public comment, again, all I'm going to say is as far as the public comment, we sent the public comment that was sent to the department to the committee. We pushed that out in several emails to you. I think the last email came out this morning to you, at least with the comments that we were provided with. Some of those comments relate to the administrative review permit. There are other comments that related to the conditional use permit, but we did push those comments out to the committee. I did receive numerous phone calls. Again, technically, phone calls to the department really are not a public comment. They should really be in writing. But I did receive also personal calls to my phone. And I'm assuming the county board, including all the county board supervisors, received comments to your emails. What we're talking about today is an administrative review permit. The department issued an administrative review permit number 2200112 with an approval letter dated March 8th, 2022 that was actually given to Mr. Bangstad's consultant at the time, Mr. Christopher Nauman. And again, I'll read that quickly. Dear Mr. Nauman, an administrative review permit is hereby.
Fast though.
Oh, really? I gotta slow down. An administrative review permit is hereby issued, and sorry, I can also provide some of this stuff to you in case. An administrative review permit is hereby issued for the project listed above, contingent on the following conditions. The project is commenced within 2 years of date of issuance. Nature and extent of the administrative review permit shall not change from that described and approved herein. Signage conform to 9.78 sign regulations of the United County Zoning and Shoreline Protection Ordinance. If exterior lighting is installed, it must be downcast from above. Dumpster to be screened from view. Applicant to recycle waste materials is required. 6, no outdoor sales, displays, storage, or activities of any type allowed. 7, future tenants to apply for an art or cup as needed prior to occupancy. 8, proper permits to be obtained prior to the start of construction, which are town, county, and state. 9, subject to stormwater management and erosion control plan, and to be directed and or diverted on property. Town of Minocqua reviewed and approved on March 7, 2022. Highway access to comply with Wisconsin DOT requirements, subject to the United County Health Department requirements. 12, pursuant to 9.77F exemptions or potential increases, reductions for required parking space. The town of Minocqua modified parking requirement as follows. A minimum of 6 parking spaces must be provided, each with a minimum width of 9 feet and a minimum depth of 20 feet. B, the town will waive the 5-foot setback along the east lot line, provided a curb is installed along the east lot line. C, site layout shall be one-way traffic flow as presented. Signage shall be required to indicate such flow. 13, please be advised that the town of Minocqua has additional requests. They're later dated December 28, 2021 is attached for review. And again, we did not incorporate some of those concerns within this part. Just a failure to comply with all these conditions will invalidate its approval. If you feel you have been agreed by the above conditions of approval, you may appeal this to the United County Board of Adjustment, and we gave it a deadline. Do you guys all have the? Yeah, here's the actual ones. Anyone who needs them. Yeah. And the last thing, so that was the administrative review permit. There is a comment from Scott Holowinski, which you want me to read in the record. And for those of you who do not know, Scott Holowinski is the chair of this committee, and he sent an email dated July 25th, 2023 to Mike Timmons, the vice chair of the Planning Development Committee, committee members, and the public attending today's meeting. I'm sorry I could not be present for today's hearing. I felt it was time and important to stop sending out threats to Mr. Bangstad about his continuing violations and have the committee decide if they felt it was necessary to consider amending, suspending, or revoking his ARB. There is a lot of history to this ARB, which will be presented today. Mr. Bangstad is trying to get what he wants by using politics to divide the public with false statements instead of applying the laws and ordinances that apply to everyone. As far as I know, every business in Minocqua that has been given a parking exemption still has the original parking requirements. The exemptions were for additional parking as part of the expansion of the business. Mr. Bangstad, our parking requirement was 7 parking spots with only 6 approved in his ARB. To get outside seating with his cup required an additional 31 parking spots. His cup application only had 1 parking spot on his property and 5 spots on the property owned by someone else. We could not approve his cup as presented. Prior to submitting his first cup application, Mr. Bangstad sent the following 2 emails. This is the Minocqua Town Chairman, hi Mark, Kirk here. I've decided to stop fighting the town and adhere to the original terms of my ARB. If the committee decides to go that way, I'd like to apologize for the public ridicule I've heaped on you and other members of the board over the last several years. While I disagree with the outcome of many of the town board decisions, I'd like to move forward with less animosity and friction. Given that I focused my ridicule on you in particular, I find it very big of you to accept my apology and move forward in a positive direction. If not, that's okay too. I'd love to eventually share here with you in my new building or talk about how I can help bring community and positivity to the town. Take care of Kirk. And then there was an email that must have been sent to Kirk, to Scott Holowinski. And just as I apologize for targeting you for ridicule in the past, public posts about how I felt I was being singled out and the way treated unfairly by the town and county. I still believe that has happened. But I shouldn't have gone about it the way I did and should have tried to work with his assistant to achieve my goals. I know being the county chair is not an easy job, and you don't deserve me heaping scorn onto you for my customers. I hope you can forgive me and that we can move forward in positivity and cooperation, Kirk. And then also, typically, we do read into the record, at least the town comments. Yeah, one more paragraph. Didn't work. Oh, respectfully, Scott Holowinski, there are certain requirements in the industry. This is from Scott. There are certain requirements in an administrative review permit for every business. Mr. Bangstad was given those. Oh, this is the rest of it. So I read the emails and now I'm reading the rest of this statement. There are certain requirements of an administrative review permit and for every business. Mr. Bangstad was given those requirements and agreed to them as every other business in the county has been given for an ARB they received. From early on, he began deviating from those requirements and wants his followers to believe that the actions of the Planning and Zoning Committee have everything to do with politics rather than following the requirements. Our committee's job is to set requirements for ARBs and have the zoning department oversee them. If possible or practical, every ARB or CUP would have inspections to make sure the conditions are met. But the reality is that in our county, that has not been feasible or cost effective. the department must rely on the lease that they are given. Mr. Bangstad's apologies and promises have been less than trustworthy, and his actions have distorted the facts. He wants the people to believe he is a victim of selective enforcement, and he doesn't know the facts behind other business art requirements. Rather, his preference seems to be that this committee practice selective unenforcement of his art requirements. Respectfully, Scott Alowinski. Sorry about that. And the last comment was, I'll just read the email, but we did receive an email with attachments from the town of Minocqua. They are here today. It just says, hello, Carl, committee members, Attorney Fugel. For additional information, I include the following regarding the existing art for the subject business. Aside from the dumpster and outdoor service violations, no mention is made of the other items that continue to be out of compliance with the conditions of the art. Number 8, for Wisconsin DOT staff in Rhinelander, a Wisconsin DOT permit was not applied for nor obtained by owner to remove existing accesses and construct a new access. Further, according to Wisconsin DOT, the new access was not constructed to Wisconsin DOT specifications. The owner was well aware that a permit was required prior to closing off accesses and constructed a new one. That this is in continuous violation with WIS DOT and the art condition. Additionally, the required driveway access license with the town was never entered into by the owner. That's with the county, or with the town. Number 10, the new highway access illegally constructed by owner does not comply with Wisconsin DOT requirements according to Wisconsin DOT Rhinelander staff. 12A, the required parking spaces have not been delineated nor designated. 12B, the required curb has not been installed along the east lot line, causing customers to drive over property and onto public sidewalk and highway curbs. See attached photos. Failure of the owner to install the required curb forced the town to install physical delineation of the property line. Waiver of the 5-foot setback was conditioned upon installation of the required curb along the east property line. 12C, none of the required traffic flow plan, signage, and parking delineation of the approved site plan has been met. Additionally, the dumpsters have been located on the area of the site plan where the driveway access enters the property in conflict with the site plan's traffic flow and parking plan. See red cross-hatched area. And so they did provide another diagram showing where the curb was supposed to be placed. Also showing where the dumpster was placed. That is in direct conflict with the traffic flow in the parking area. And he also did provide the approval letter from March 8th, 2022. And I don't really have that much more to say. Just kidding.
Finish your comments on,
Close the public comments, and
we have, a stack of emails and that for our personal reviews. They keep coming in as we're sitting here, I've noticed, so. You guys got emails? What do you need? So, and there's numerous emails, and with that, we have to review and digest those type of things. Carl, are you done with your presentation, or you can go over the incidences? Okay. He's presenting us with a timeline of issues. Yes, please.
sorry, a lot of information. What I handed the committee were two documents, and again, I apologize for giving to the committee at this late. It's just that we did recently put these together. There are two basically documents. One is called the Minocqua Brewing Company Master Timeline from July 29, 2022 through July 25th, 2023. And the Minocqua Brewing Company Investigation Timeline, July 29, 2022 through July 25th, 2023. And I'm going to be going back and forth between both these documents. And we also did send to the committee some of the documentation that's within this master timeline, which I will try to explain and say that is part of the record. Like I stated, we did issue the administrative review permit on March 8, 2022. Again, we sent out the approval letter. And on July 29th, we did the investigation based on a complaint. There was some outdoor seating, which staff took pictures of. There was outside seating on August 1st, 2022. Outdoor seating again on August 2nd, 2022. So I sent a letter to Mr. Bangstad on August 2nd, 2022. Basically, I sent it to Mr. Bangstad's attorney, Mr. Schaefer, and I just say the following. I write to you, you understand that you are the counsel of Mr. Bangstad. I wanted to touch base on several issues. One, on July 13th, the Planning Development Committee met to discuss a letter dated June 29, 2022 from Christopher Max, Assistant Director Todd Trotsky, brought this to the committee. The committee provided guidance to Mr. Trotsky. On July 27th, the Planning Development Committee directed me to take the lead on all issues related to the Minocqua Brewing Company. 3, I will be sending formal correspondence guidance related to the decision on July 13th, and that was regarding a revised administrative review permit. I also did provide Mr. Bangstad a digital recording. And then 5, I stated the following. I'm aware that the fact outdoor seating is being provided at the Minocqua Brewing Company, contrary to our 2200112, will act accordingly pursuant to Chapter 9 of the Oneida County Zoning and Influence Protection Ordinance. So I did put Mr. Bangstad on notice that he was not in compliance. On August 3rd and August 4th, staff did on-site inspections. We did see that there still was outdoor seating. On August 4th, 2022, a citation was issued to Mr. Bangstad for violations which were failure to comply with conditions of the requirements of 515 Chippewa on 329 East Front Street. On August 5th, we did take on-site pictures that showed violations. We received a picture on August 6th that showed, again, outdoor seating. On August 11th, August 12th, we did on-site inspections and saw that there still was outdoor seating. On August 15th, I sent correspondence to 2 new attorneys, Attorneys Good and Leitner, and I'll read that quickly. So on August 15th, I sent a letter to Joseph Goody, Mark Leitner, Carbon Copy College Schaefer, Kirk Bangstad, and to other individuals. I just said Attorneys Goody and Leitner, I think that's how you pronounce it. Good morning. I write to both of you as attorneys that represent Mr. Bangstad, Minocqua Brewing Company, in an effort to give you some background information related to your client and attempt to be fully transparent. Department staff was contacted by a representative of Minocqua Brewing Company about opening a retail service establishment to sell items including beer from the Minocqua Brewing Company sometime in the spring of 2021. The parcels involved were parcel numbers MI3240 and MI3239, address 329 East Front Street, Minocqua, Wisconsin. Part of the overall plan was to possibly have an outdoor seating area so individuals could sit outside and drink products sold by the Minocqua Brewing Company. Representatives at that time were told that permits would be required for retail establishments with outdoor seating. The parcels involved are under the jurisdiction of Chapter 9, United County Zoning and Influence Protection Ordinance, and their own Business B6 or District 6, Business B1. That's the only district requires an administrative review permit pursuant to 9.26 for any new retail establishment that does not have a drive-through or drive-in component and does not have outdoor operations other than customer or employee parking. Furthermore, a conditional use permit is required pursuant to 9.26A4C for any retail business, office, professional service establishment that involves drive-through or drive-in components or has other outdoor operations other than customer and employee parking. This department has been consistent in articulating the requirements of Chapter 9 to Mr. Schaefer, Mr. Bangstad, and Mr. Nauman. To my knowledge, there has been no legal or other arguments on the requirements spelled out in 9.26 District 6B Business B1. I'm providing some of the emails between the representatives of this department and Minocqua Brewing Company. The Minocqua Brewing Company made a decision to move forward with our clearly understanding the need for a cup if outdoor seating was to be established. Our permit 22-00112 also has condition number 6 that states no outdoor sales, displays, storage, or activities of any type is allowed. Our permit 22-00112 also spelled out your client's rights to appeal the conditions of approval of the Oneida County Board of Adjustment. An appeal was never filed. I've enclosed a cover letter for our 22-00112. On August 2nd, 2022, I sent an email to Mr. Bangstad's attorney, Colin Schaefer, giving an update of matters related to the Minocqua Brewing Company. Both of you, Joseph Goody and Mark Leitner, were provided that email. As part of that email, I informed all parties that the department was aware of outdoor activities taking place on the property. There has been no response from anyone except to inform me that Attorney Goody and Leitner represent Mr. Bangstad. On August 4th, 2022, a citation was issued for a violation of Chapter 9 of the United County Zoning Shoreline Protection Ordinance. I issued the citation because I believe your client is fully aware of the requirements of the art that was issued. Furthermore, I believe your client is fully aware of the need for a cup for outdoor seating and has been aware of the fact over a year. I had no contact with Mr. Bangstad, his attorney, after the citation was issued. I stated where I sent it to. When the citation was issued on August 4th, 2022, there was one tent being used for outdoor seating. On August 12th, 2022, staff took pictures of 2 tents being used for outdoor seating. Picture enclosed. I state to both of you, the department is getting pushed by the actions of your client to have to take enforcement action pursuant to Chapter 9 that includes citations for date-specific violations or have the ability to take the continued violation of our 22-00112 to the Planning Development Committee pursuant to Chapter 9, Article 8, specifically 9.82, for them to amend, suspend, or revoke the permit. I again state, I am aware of outdoor seating being provided and now being expanded at the Minocqua Brewing Company, and we'll have to take enforcement action pursuant to Chapter 9 of the United County Zoning Shoreline Protection Ordinance. I am more than willing to discuss with you in person, via virtual Zoom meeting, email, phone call. If you desire to do so, I would have representatives from the Corporation Council. Thank you. So that was the second notification. On August 15th, 16th, 17th, 18th, and 19th, we did basically see outdoor seating, again with 2 tents and chairs outside. On August 19th, second citation was issued. Failure to comply with conditions and requirements at 515 Chippewa Street and 3290 Front Street. On August 23rd, August 24th, August 25th, August 26th, August 29th, I basically, staff saw outdoor seating. So on August 29th, on August 29th, 2022, I sent a certified letter to Mr. Bangstad, and this is regarding administrative review from the 22-00112. It said, Dear Mr. Bangstad, again, the first paragraph is standard zoning enforcement language. The second paragraph was the department issued administrative review from the 22-00112 on March 8th for the above described property and enclosed a copy of the approval letter for your reference. On August 2nd, 2022, an email was sent to your attorney at the time, Colin Schaefer. The email stated that the department believed that there are violations of Administrative Review Permit 2200112. On August 4, 2022, citation 5817 was issued to fairly comply with the conditions and requirements at 515 Chippewa Street and 3290 East Front Street. On August 15, 2022, an email was sent to your attorneys, Joseph Goody, Mark Leitner, providing background information regarding the Administrative Review Permit 2200112, and again stating that the department believed that there were violations of Administrative Review Permit 2200112. On August 19th, a citation was issued number 5189 for failure to comply with conditions and requirements at 515 Chippewa Street, 3290 East Front Street. Since that time, the department has documented 5 occasions that outdoor seating is still being provided to customers of the Minocqua Brewing Company, contrary to Administrative Review Permit 2200112. Condition number 6 that states no outdoor sales, displays, stores, or activities of any type are allowed. Furthermore, it appears that there are additional violations of Administrative Review Permit. Condition number 5, dumpster be screened from view. Condition number 12, which was the parking conditions. I also did state language that the acting chairperson read pursuant to 9.82 enforcement and penalty states revocation. I then gave him that language, and I said, please be advised that if you don't immediately come into compliance with the conditions of Administrative Review Permit 2200112, the department is left with no other options but to recommend to the Planning and Development Committee to amend, suspend, or revoke your Administrative Review Permit because of your non-compliance with the provisions of the permit. You are hereby ordered to bring your Administrative Review Permit, and we're going to run this number 2200112, into compliance immediately, including discontinuing providing outdoor seating to your customers. Please be advised that each day the situation continues may be considered a separate and distinct violation. On August 30th, August 31st, September 1st, September 2nd, September 6th, September 7th, September 8th, September 23rd, I believe we have documentation staff of outdoor seating. On September 26, 2022, I issued the 3rd citation for violation of failure to comply with conditions requirements of 515 Chippewa Street and 3290 East Front Street. In the meantime, conditional use permit was submitted to the department, and then we're going now into 2023. On May 12, 2023, on-site photos taken up to our podium, display rack, 2 tables and chairs set up outside with people sitting at the chairs. May 15th, I did receive correspondence with Kirk Bangstad and Carl Jennings informing Carl that there will be a beer release party next Friday with 100 people or so. I believe I did provide that to the committee, I just couldn't find it. But basically, it was just an email that was sent to staff, basically informing that they were going to have a food truck and outdoor seating at the Minocqua Brewing Company. And then the paraphrase says, I decided not to apply for a special event permit, nor ask the town to allow me to find a food truck for this event, because I know they will say no. If you want to find me now for any violations, this might cause go for it, but this is what I have to do for this party. On May 15th, we did an on-site inspection. May 18th, on May 18th, I stated to Mr. Bangstad, enclosed a letter that will be mailed today. On May 18th, 2023, I sent a certified letter to Mr. Bangstad, which basically said as follows: Mr. Bangstad, the above described trust real estate is located within the 1920 Insurance Protection Ordinance as amended December 14, 2022. The responsibility of the zoning, the responsibility of the department to ensure that all use of public described real estate is in compliance with the provisions of the ordinance. The planning and zoning department took the closed pictures at approximately 12:50 on May 12, 2023. Pictures show individuals sitting in an outdoor seating provided at the above described property. Furthermore, it shows merchandise being sold outside of the actual structure. The planning and zoning department previously sent you a citation for violations on August 4th, August 19th, and September 16th, 2022. Again, I articulated what the condition number 6 stated. The department issued administrative review permit 22-00112 for the operation of craft brewery retail outlet at the above described real estate. Condition number 6 states no outdoor sales, displays, storage, or activities of any type allowed. On May 15, 2023 at 7:09 a.m., you informed the department that you'd be having a beer release party possibly on Friday, May 19th. In the email, you stated that you possibly were going to have some outdoor activities and or the placement of a food truck. You also acknowledged that your event could potentially constitute a violation of your permit and the ordinance. Again, our 22-00112 states as follows: no outdoor sales, displays, storage activities, any type allowed. Just stated, please be advised that each day this violation continue to be considered a distinct and separate violation for which this department may seek injunctive relief. And then we provided him with the picture. On May 19th, again, which was the day of the event, we did observe a food truck, which the Minocqua police officer spoke with operating, that was removed. But again, it was outdoor clothing display racks that were on the property. May 25th, I sent an email to Mr. Bangstad stating as follows. Mr. Bangstad, as I attempted to communicate in my last email, as we discussed in the past, the Planning and Zoning Department is not in a position to negotiate over the terms and conditions of your existing permit. The permit was issued by the department with certain conditions, and those conditions need to be adhered to. Department's enforcement authority is told in 9.82, which I provided. Possible penalties for violation of the permit or ordinance include but are not limited to daily forfeitures, injunctive relief, and/or amendment, suspension, revocation. The department has no authority over the administration of city, village, or town ordinances. That is why I directed you to the town of Minocqua for any questions you may have regarding the enforcement of ordinances. If you have any additional questions or concerns that you'd like to address in person, I am the person whom you should address those questions or concerns rather than that of my staff. As I stated previously, I am not available to meet with you tomorrow, but will be available. If you'd like to set up a meeting at the end of next week, please let me know if you would be available. And again, that was in response to an email that Mr. Bangstad sent to the department. May 30th, May 31st, June 1st, June 2nd, June 3rd, 4th, June 5th, June 6th, June 7th, June 8th, June 9th, 10th, 11th, 12th, 13th, June 5th, June 14th, June 15th, June 16th, 17th, 18th, 19th, 20th, 21st, 22nd, 23rd, 23rd and 4th, 26th, 27th. We staffed it. Notice 2 tables and chairs primarily set up on the outside of the building. Also some clothing rack displays. At that time, a letter was sent on June 29, 2023 to Mr. Lester Pines, who's corporate or his counsel for Mr. Bangstad, from our corporation counsel, Mike Fugel. The letter states as follows: Dear Attorney Pines, Administrative Review Permit 22-00112 was issued on March 8, 2022, relative to your client's property located at 3290 East Front Street, Town of Minocqua. Last year, Oneida County issued 3 citations to Mr. Bangstad due to violation of administrative review permit. On May 15, 2023, Mr. Bangstad advised Oneida County via email that he was planning a beer release party. On May 18, 2023, Carl Jenner, Planning Development Director, sent a letter to Mr. Bangstad outlining and observing violations of the above described administrative review permit and advising that the violations may result in the United County seeking injunctive relief and forfeitures. I write today to advise that the violations identified in Mr. Jenner's letter of May 18, 2023 have not been remedied or remediated at all and have continued on a daily basis. Additionally, it appears that Mr. Bangstad has not complied with one or none of the conditions of the administrative review permit of the ARPA. I understand that Carl Jenner agreed it was reasonable not to pave the parking lot during the pendency of the conditional use permit application. That in no way initiated Mr. Bangstad's responsibility to comply with the remainder of the ARPA. I would request that you speak with your client and that the property immediately be brought into compliance with the conditions contained in the ARPA. Mr. Bangstad continues to flagrantly disregard the conditions contained in the ARPA. Oneida County will initiate enforcement. Enforcement may include initiating a civil complaint and or revoking the administrative review permit. On June 29th, we did document tables and chairs set outside. On June 30th, Mr. Bangstad sent me, or on June 29th, Mr. Bangstad sent me an email saying, "Hey Carl, can you explain to me why Attorney People is writing my attorney about these alleged ARPA violations? Can't we talk on the phone about this? You have yet to give me a citation for these alleged violations, which suggested to me that we had discussed about how the concrete slab is still part of my building made sense to you, and thus you haven't determined that I was violating the ARPA. But now we're getting a note from the county attorney suggesting that I'm in violation. Why can't we just chat together? Because you're the enforcement agent, I'm the business in question. Why do we have to involve lawyers when your lawyer is paid for by United County and I to personally pay mine to respond to these questions? Can we talk today? Tomorrow is going to be a very difficult chat." On June 30th, I responded as follows. As I stated previously, I and the department are not able to negotiate over the terms and conditions of your existing ARPA. The permit was issued by the department with certain conditions. Those conditions need to be adhered to. Please view my May 18th letter in the ARPA. Please be advised the department has recently received a complaint concerning the dumpster that it was to be screened. As I also stated previously, advised you penalties for continued violations of your permit include not only daily forfeitures but also enforcement action to obtain injunctive relief or suspension of the permit. On June 30th, July 1st, July 2nd, July 3rd, July 4th, July 5th, July 6th, July 7th, July 8th, July 9th, July 10th, July 12th, July 13th, July 14th. Staff took on-site pictures and tables and chairs were set up outside on and off the pavement. On July 15th, the department received correspondence from Mr. Bangstad. That was really to the whole county board, which is part, and he said, "I respectfully submit to the United County Board as well as county attorney, my attorneys Lester Pines, and the United County zoning officials and Mark Roddy, DOT. Basically, it states as follows. This picture was taken at approximately 8 p.m. on Friday night, on July 15th, arguably the busiest day on probably the second busiest tourist week of the Minocqua over the entire year. This is a picture of a completely empty public parking lot directly north of St. Matthias Episcopal Church, within a 30-second walk to the Minocqua Brewing Company. What's more, I included a screenshot of testimony from our customers that she came to visit us twice during the busiest week of the summer, the week of July 4th, and was easily able to park there. This is proof that there is absolutely no need for parking at my establishment. My customers can easily find parking within a minute walk of my business. Your own county zoning officials provided an analysis that shows that Oneida County has awarded approximately 12 businesses, over 200 parking exemptions in Minocqua Woodard over the last 2 years, most notably Rocky Reef Brewery, the Yacht Club, Cafe, Sonder. All businesses almost exactly like mine that sell alcohol are within a few blocks of us. Carl Jenner told me that the zoning commission's vote on my cup was going to occur on August 2nd. I just found out that the zoning committee scheduled a public hearing on July 26th to revoke my ARP for violations that would have been nullified if the ARP, if they had approved my cup four business days later. My cup, which is asked for 6 parking exemptions to build a beer garden, is an obvious permit to approve given the data I just laid out to you in this email, as long as the county board believes in fairness. I ask you to stop this public hearing to revoke my ARP, or at least combine this hearing with the hearing to vote on my cup, which we applied for in May. And the vote has been delayed 2 months, which I can prove is causing $2,000 to $3,000 per day of lost revenue. And then P.S. Carl Jenner told me personally that I have 2 years to fill my other elements of my ARP, and since my current cup in front of the county board would dramatically change my ARP, it makes no sense to fill my ARP until the cup has been voted on. And that's July 15th. On July 18th, July 19th.
You're missing a member. You're missing a member of the board.
We have 3, we have a quorum here.
Sorry. On July 18th, July 19th, July 20th, July 21st, July 22nd, July 23rd, just wait. July 22nd, chairs were set up outside. On July 23rd, tables and chairs were set up inside. On July 24th, we received correspondence from Mr. Bangstad's attorney as follows. This regarding the Minocqua Brewing Company Administrative Review Permit 22-00112. And I think this was based on the fact that Corporation Counsel sent Mr. Bangstad's attorney an email. It says as follows: Dear Mr. Fugel, thank you for sharing with me photos of the Minocqua Brewing Company, the company taken on Saturday and Sunday, July 22nd and July 23rd. Respectively, they show that while the tables previously were outside the company's premises, there were folding chairs that were outside. In some cases, customers were sitting on them. I confirmed that the folding chairs were not placed outside of the company, and no service was provided to any individual sitting in them. They were taken outside by the customers who were likely merely trying to get some fresh air. The staff working at the company last Saturday and Sunday were unaware that allowing customers to do so would constitute a violation of permit prohibition on outdoor activities. The company's owner, Kirk Bangstad, has now specifically directed his employees to ensure that no customer takes any chairs outside. As to the children playing on the rocks, and they're apparently having done chalk drawings on the sidewalk, customers just standing outside the building, I'm certain the committee would not consider such behaviors outside activities that violate the permit. If my assumption is incorrect, please let me know immediately, and the company will take steps to see that such behaviors cease. I want to once again assure the committee that the company has taken the necessary steps, and I will will take any others needed to ensure its compliance with the above referenced permit. Sincerely, Lester Pines. On July 24th, we took pictures, tables and chairs up inside. July 25th, we took pictures and folding chairs folded inside. And I think, I don't want to talk about it, but that's the record to this point.
Hey,
Lester.
now, Mr. Bangstad will be opportunity to address us.
Just
Mr. Chair, Mr. Jennifer is going to call Lester Pines, counsel for Mr. Bangstad. Attorney Pines requested to address the committee by phone, and you had permitted that to occur, so Carl's going to call him right now.
Also, while Carl is calling him, this is Kirk Bangstad, owner of the Minocqua Brewing Company. While Carl is calling him, he is not.
Speak in the microphone, please.
While Carl is calling Lester, just let everybody know that Lester, my attorney, has not been allowed to join the Zoom call for this entire reading. For this entire reading of the violations, because the Zoom call has been overloaded by people from around the country joining. I'm not going to argue that, but I think it's a little bit weird that my lawyer can't hear all these emails that happen. And I also believe it's weird that Chairman Holowinski and Mike Roach, Chairman Holowinski and Mike Roach, you don't be quiet. What are you gonna? I'm already out of order. What do you think? You've already said I've been out of order for 2 years.
Sorry.
Calm down.
Thank you.
I will. Thank you. And again,
This is your attorney going to
what
speak.
we're calling into is the United County Boardroom, with the Plan Development Committee, your findings here, a lot of this media, so that's let it go. Lester?
Yeah.
Yeah, I think the chair, you recognize
Yes,
that?
I can hear you, Lester.
Lester, the floor is yours.
Thank you. I very much appreciate that the committee is giving me an opportunity to address it on this matter. It was impossible for me to travel to Oneida today to appear in person, although that would have been my trust. I have been in touch with Mike Fugel, the County Corporation Counsel, over the last 10 days regarding this matter. I exchanged a number of letters with him, which I believe have been shared with the committee. I totally understand that the committee is concerned about the permit and issues that have arisen with regard to Minocqua Brewing Company's compliance with it. When I spoke with the Corporation Counsel, I told them that and want to serve the former of the committee retained me recently to assist him. And the assistance I have provided to him is to ensure that that I improve the lines of communication between him and the county, and that I helped to assist him to correct the alleged violations that were extant at the time, which really, most particularly, and I think the committee has heard about these violations, have to do with the outside activities prohibition in the permit, and with regard to the that seem to be one with needed immediate attention, and they got immediate attention. And I assured the Corporation Counsel, and I want to assure the committee, that the company wants to make sure that it is cooperative with the county and is responsive to the county. To that end, I have suggested that when there is communication with Mr. Bangstad or the company generally about a concern regarding whether or not the permit is being followed, that I be informed at the same time. And when that happened now in the very recent past, since I've been retained, those two issues were addressed. I know that I was unable to hear the presentation of the staff that because the Zoom meeting was completely full both on telephone and visually. Well, I understand that the staff observed these recent violations and called them to the attention of the company, and those were addressed. Now, what happened last weekend was that some people who were inside the premises brought some chairs outside. The staff who was working that day did not realize that that would be a violation. When that was brought to my attention by the Corporation Council, we addressed those immediately, and the staff was directed to ensure that even though the doors are open, that no one is allowed to go outside with such chairs. With regard to the other aspects of the permit, I don't know if they were addressed, having to do with certain construction, clothing, and so forth. The permit allows that to be done within 2 years. And the request for additional use permit, which will be heard on the 2nd of August, I believe, that would enable me to really deal with these issues very in a very direct and prompt way. But the bottom line is that today the committee is looking at a very, very serious determination, and that is whether or not it will seek to revoke the permit. And I want to suggest to the committee that the revocation of the permit that allows a business to operate should really be done only in circumstances where the violation is creating a danger to the public or to the community. There is no such, now, obviously the committee has discretion, but if you exercise the discretion, I suggest to you that those are the considerations first that should be looked at. Because this is a vital and is a viable business that is bringing not only a benefit to the owners of the business, but it's also bringing a benefit of tourists to the county, and it is part of the entire business climate. But for a county to shut down a business for violations such as the ones that have occurred, I think it is a step that is so serious that before doing so, that there really ought to be rationale for why there is a danger or why there is something that is really badly affecting the community. Now, with regard to the Minocqua Brewing Company, what I want you to know is that with the improved lines of communication, that there will not be further violations of this. The business is to grow and prosper and to have the town of Oneida grow and prosper with it. That's what it wants to do. And so that's something that is important for the committee to consider. Essentially what I'm saying is that the business wants to have a better relationship with the county and with the town. And I have been retained to assist it in doing so. I have made progress on that to date. I intend to make more progress in the future. The benefit that Oneida County and the town of Minocqua will have from allowing the business to continue with improved lines of communication will far outweigh any benefit that the community would have from closing the business. closing the business will just increase liability, and will not benefit anyone. The committee might say to itself, the members might say, well, we have to be firm in enforcing all of our rules. Always, for all businesses. And so we're starting right now to say, never again will we allow any violation of permits to occur, or we're going to really come down hard on that business. And I would like to maybe just take a step back and say to itself, with the two lines of communication, as I said, for me, that the business ought to have an opportunity to go forward and continue to grow, continue to benefit the community. And if I would be surprised if you wouldn't see a tremendous difference in how things work in relationship between the and the town victim. So I'm asking you to take a step back, realize that there was immediate progress when these latest issues were brought to my attention on behalf of the company. Do not revoke this. I will continue with a improved line of communication and go forward to consider in August the conditional use permit. And I do want to comment, although I didn't hear the presentation of the staff, I do want to comment on this parking issue. The condition of parking has been made, of achieving the permit goal of parking has been made difficult by the town of Minocqua, which had it was a property which it never knew it owned before, but will not make it available for it. And which does not require parking for 147 years. And that's a matter that we want to take up at the hearing on the conditional use permit, and with that whole hearing.
Thank you.
Parking is really not the big issue. The big issue is ensuring that the relationship between the business, its owner, the town, and the county is improved. That's what I hired the team to do. That is what I have started to do. I have had success with that. I intend to continue to improve on that relationship and improve on that success. And I urge the committee to recognize that and to allow us, when I say us, to allow me and Mr. Bangstad and the company to move forward with a new style of communication and a new ability to get things done without conflict. And that's my presentation to you. I'm sorry that I can't answer questions. I understand that that's not part of what I'm allowed to do through this telephone presentation. But I also finally just want to say, I don't put myself out in this way without having really given great consideration to it. And I have given that consideration, and I really want to ensure that the business, Oneida County, the town of Minocqua, and the entire business climate in the community is improved by improved relationships with my clients and me. I think you will find that that is something that will be very beneficial to everyone. And I thank you for taking the time to listen.
Okay, thank you. Okay, Kirk.
Okay. Do I sit here and talk? Or do you want me to go to the lectern?
Sit right there, use your microphone.
Okay.
Is your microphone turned on?
Check.
Yeah, turn it on. The green light's good.
Just want to make sure we had it all right. Okay. So I have a written statement here. I wanted to first bring up the fact that we're missing two, I believe, of the 5 or 6 people that are supposed to vote on this today. I believe Scott Lewinsky, who's the chairman of the entire county and also in charge of this committee, who seemingly has a big role to play, is not here. And Mike Roach seemingly left about 20 minutes ago. I'm not sure if he's coming back. It's really unfortunate that my lawyer just gave a really wonderful presentation on my behalf, and 2 out of the potential 6, and I'm not sure, Billy, are you a member of the committee or are you sitting in? Okay, because I thought there were 5 members. Okay, all right, so this is my presentation. I'm submitting to the record that I think that there's something weird happening when 2 out of the 5 people are not present to hear our side of the story. Secondly, we've had a huge, long recounting of all the violations that I've apparently done in the last 3 years. But we have yet to read in total, probably 8,000 emails collectively that all of the Oneida County board members got. If you multiply 380, which Linnea was quoted as saying that she had received in the news last night, times 20, that's around 8,000 emails. If we were really going to do this right, we'd have to read all those emails, just like you've read all the violations that have occurred to me over the last 3 years. Secondly, I've submitted to you in email form at 10 a.m. this morning, all of the Oneida County board members, another 4,864 signatures to an online petition. Local residents, local second homeowners, tourists, and would-be tourists who have added their support to my company and what my company brings to tourism in Minocqua. Also, the Zoom situation here only lets 100 people in. My lawyer wasn't even able to get in to Zoom to listen to this presentation. It is full of people in support. I believe probably a vast majority have tuned in from outside of this community in support of my business. To not allow those people to speak on email or to read the emails, to not allow anybody to chime in on Zoom who are potential tourists in a community that relies 100% on tourism, I believe is showing that you don't really care about listening to tourists. So that's something I have to do just before I make my statement. I want to point these things out to people listening to the news. So let's get to the issue of the violations. I'm skipping my reference to Barabbas and the gospel for time's sake. So let's remember, before we get in, I'll read this. Let's remember that what has led to these violations, my simple request to build an outdoor space for our customers to drink beer. I sent you all a picture of our building before we bought it that I found on Google. The owners of this building, a bike rental shop named Z-Best Bikes, was John Camacho. As you can see in this picture, John has put all, and I sent it to you.
We're discussing the revocation of your permit, none of the history. This is on your permit. If you got, he's
Tim,
giving
Mike,
you the history
you just
of the
read
violations.
Scott Lewinsky's recounting of all the history. You just read that into the record.
Of the violations.
Yeah.
That is what we're talking about, not the perception of where you've asked permission and where you've got your first conditional use permit was denied. This is strictly on the administrative permit that was.
I will address it. I'm leading to it.
Okay.
Can you understand? I mean, I'm getting there. I promise. I want to build a better relationship with you guys. That's what my lawyers. So, okay. So the owner of this building, a bike rental shop named Z-Best Bikes, was John Camacho. As you can see in the picture that I sent, John put all his bikes in the area directly in front of his building and wasn't required to have parking. My understanding is that John operated this building for at least 20 years. I may be off on that, but I believe that's the case. Note the space that John put his bikes is what we now refer to as the pork chop. When I bought this building, I was informed by my architect that this land was not ours, but that we still had plenty of room to build a beer garden. But my architect did not. He wanted to make sure that we had all the agreements in place to use that parcel of land like John Camacho had done. So we started searching for who owned it. We asked the Department of Transportation, who said it wasn't theirs. We asked Oneida County, who said it wasn't theirs. And then we finally asked the town of Minocqua. They said they weren't sure who owned it, but that they'd get back to us. Well, when they got back to us, they said it was theirs. And around that time, they also said that we needed to build 7 parking spaces on our lot and couldn't use the town's newly discovered land. Note that this conversation took place back in September of 2021. And what we didn't know back then was that the town of Minocqua does not have the jurisdiction to require commercial parking from businesses. You guys do. The town of Minocqua is an unincorporated town without a zoning department. But we didn't know that at the time, and we felt completely stuck because adding 7 parking spaces was impossible for us to structurally do. You just couldn't fit 7 parking spaces in that area. So we went back to Carl Jenrick and told him that. But instead of working out a solution with the zoning staff that are hired to figure out the problems like this, we were forced to negotiate this parking impossibility in many subsequent town board meetings, even though the town board had no jurisdiction. I repeat this. Multiple town board meetings where they didn't have a jurisdiction to force us to have parking, but we had to somehow negotiate with them on parking. We finally negotiated.
Get it back to the revocation.
I am. I'm moving it there. We finally negotiated 1 less parking spot to 6 to enable us to do business there at all. The vote was 3-2, and Mark Hartzheim and another member of the Facebook hate group that is now 800 strong, John Thompson, voted to hold us to those 7 spots, which would have effectively put us out of business. Let me repeat, 2 out of the 5 Minocqua town board members wouldn't capitulate to one single one.
On your permit today.
When we signed the document, it was already February of 2022 that said that we needed to put in these 6 spots. We desperately needed to start rehabbing that building, which is now going to be on the National Register of Historic Places.
Okay, Kirk.
It will now be on the National Register of Historic Places in 1 week.
Kirk.
You followed me here out of, and
I know that, but this is on your permit, not on all the history and everything else that we've got here.
Thinking I had been beat, I put a deposit down on $50K to dig an underground drain to connect to allow to safely drain from a future parking lot, and furiously set to work rehabbing our building. We soon realized that we would be able to safely open in the summer of 2022, but we wouldn't have everything in an AR hall fully completed.
Kirk, one more
Still
time.
mistakenly thinking that the town had jurisdiction over our building permits, we sent a letter to Town Attorney Harold asking the town to work with us to open for the tourism season, given the businesses that make most of their money in Minocqua in the summertime. Even though our building was safe to open, Attorney Harold wrote back and told us that we wouldn't be allowed to open until every item on our ARP.
Right now, folks.
Note that he didn't have the authority to make those
taking
changes.
a 5-minute break because we are
They're
getting
probably making this break so they won't allow me back into this room. They might physically not allow me back into this room to make the statement which I have come here to make to defend my business being shut down by Oneida County. I feel I have every right to speak my piece when my entire business might go up in smoke because of this board member. By the way, there are 2 people in this meeting who are not here. There are 2 people in this meeting, Scott Holwinski and Mike Roach, who have left the meeting, yet they're still supposed to hear my testimony. And now they're not allowing my testimony to happen because they're not allowing my testimony, even though I've written books and they are not allowing me to talk. Why are they not allowing me to talk right now? I would like to read. Mike, can I just finish my statement? Mike,
Mr. Bangstad. Mr. Bangstad.
Mr. Bugle.
You may want to step in the
Mr.
hall.
Bugle.
Mr.
I would
Pine is
prefer-
going to call you.
I would prefer to finish my statement. Can I finish my
Mr.
statement?
Pine, I don't know what else to say. You're going to call him.
I would like to finish my statement. We quickly looked up the records at address and discovered that no less than 500 retail businesses have operated
It's on hold. Whatever he's saying is on his hold.
without being forced to hold a per business permit. At that point, I knew we'd never get a fair shake in the town of Oneida and Oneida County.
Now, if you did what you're supposed to do,
And I figured I'd eventually have
No comment from the crowd. Mr. Bangstad's attorney is going to contact them.
Customers came and wanted to drink beer outside. That summer, thinking I was going to end up in court anyway, I put up tables and chairs outside to reserve my beer. I think I had to raise money somehow to pay the lawyers I had to hire for this fight. So those violations last summer, I do admit to them. But since June 2022, I filed for 2 conditional use permits to serve beer outside to my customers. The first permit took a year of still walking through town and county delays. And that permit asked the county, not the town, to allow it to put parking in this disputed court traffic. If they wanted parking so badly, why not put it in the most obvious spot, which was the court traffic? It took a year for the county and the town to shoot that option down, slow walking it in here until it's put us in a dire situation once again before the summer tourism season. However, at that meeting, the Oneida County Zoning Department did an analysis that showed the town of Minocqua had given out, listen, 174 parking exemptions to 11 businesses over the course of the last few years. Some of them included 47 exemptions. The yacht club got 47 parking exemptions to build an upstairs bar above on their roof. They got 47 parking exemptions. Rocky Reef Brewery, who is a brewery, they got 30 parking exemptions to build a beer garden, and they are in the town of Woodruff, and this county said yes to that.
Ladies and gentlemen of the audience,
However, at that meeting,
at this time, I'm adjourning this meeting.
47.
We are done for today. The meeting is over. Thank you.
Not only that, but this analysis also showed that the Oneida County Zoning Department